May I please, Lordship? Wait. So this is a case, we were the people who had carried the matter to this honorable court and succeeded. And in the revision, there, I'm sorry.
Yeah, please go ahead.
This is a case, Manoj. There was recruitment and the initial notification had vacancies of about 6,379 vacancies. There were two independent litigations there, Manoj. One which has attained finality for the reservation for people who have studied within the state of Bihar from government college polytechnics or private polytechnics. Insofar as government polytechnics, there was a reservation provided of 40% for state reservation. The private institutions in Bihar, those students were not governed by the reservation policy. So they challenged it and their challenge was accepted. And that judgment of the High Court has been acted upon, a revised list was made. Para 24, the Supreme Honorable Court's judgment records that fact and a revised list was prepared. Incidentally, there was a parallel litigation which was for the requirement which asked for a mandatory registration or approval from the AICTE for those colleges which are affiliated with the universities as well. And the AICTE itself had given a public notice saying that such affiliation is not required. So on a concession by the state government, those writs were withdrawn. The state government, while the writs were being withdrawn, says that we will cancel the whole selection process. So aggrieved by that cancellation of the whole selection process, we who belong to the 60% of the unreserved outside candidates who are eligible and were included in the original press selection list made pursuant to the 9th April order of the High Court, which has attained finality, noticed by Lordships in para 24 of this court's judgment. We were now knocked out, my lords, the fresh revision. What has happened is the scope of the remand or the directions were, my lords, para 29. Lordships may kindly see page 98 for a moment. My lords, I'll just place the judgment and make my point. This is the limited scope, my lords, why we seek contempt. Lordships at page 99.
Which part of the order has been disobeyed by them?
Yes, my lords. Great respect. Para 24 for a minute, my lords.
No, directions are not.
No. I'm just showing the factual position.
Come to paragraph.
Just two paragraphs, my lords. Only two paragraphs. Para 24. Lordships authored the judgment, my lords. I'm very conscious. Therefore, I'm just trying to place one para, my lords. Para 24. It is pertinent to note that the order dated 19th April 22 does not appear to have been challenged further and has attained finality. It is stated by the BTSC that the final select list was prepared and kept under sealed cover. While an application seeking release of the list was pending before the High Court, the writ petition was withdrawn. So I am part of the select list which was already there. Now, Lordships will kindly come to para 29. The directions.
You're part of that sealed cover list.
Sealed cover list.
How do you know?
No, that was available, my lords. It was produced before this court. Subsequently, when the appeals were pending. And that's not in a dispute, I was.
I may just point out the sealed cover, it was produced before the honorable judges and it was not made.
No, my lord, this annexure is here, my lord. Both lists are in the public domain. Both lists are annexed with the petition presented.
Afterwards, the.
Yes, it is in public domain, my lord. It's part of this petition itself. I give the page number. And in fact, para 29, in the light of the aforementioned position, the state action of scrapping the entire selection process is not permissible. In view of the peculiar circumstances of this case, particularly the prolonged pendency leading to huge number of vacant posts, the government's functioning, this court finds it appropriate for the state BTSC to proceed with a fresh select list submitted in compliance with the order dated 19/4/22 in so and so, which has attained finality, has also taken into consideration as far as possible the interest of the candidates who were found successful. Hence, fresh select list must be appropriately revised in the following manner. The directions, Lordships. Fresh select list to be prepared in view of the order dated 19/4/22 passed by the CGR that has been prepared, my lords. We were included is my case. Fresh select list will also include as far as possible those meritorious candidates who were otherwise eligible but were declared ineligible solely on account of the 2017 amendment to the rules, that is on account of their institute not being recognized by AICTE. So that is the limited scope of the revision Lordships had permitted. Now, what has happened is, my lords, the subsequent list which is published, they've tampered with the entire merit list.
They will have to.
My lords, with respect,
Because large number of candidates will now come into the select list because they were denied earlier. their selection on account of the amendment under 2000 because.
Lordship, that could be
2017.
confined to those.
No, so we can't look into these individual cases in a contempt jurisdiction. If you're having any grievance, please go before the Patna High Court.
Lordship.
Not in contempt.
Lordship, may I am kind, item 34.7, Lordship. Right, this is
We will
I
give you-
completely
we will
not
give you
tagged with,
liberty.
wrongly tagged with this SLP or Lordship, the contempt petition Lordship, it's not contempt at all. Lord, I have four set of petitions Lordship before Lordships. The
We
first,
are asking for a positive direction now. This miscellaneous application is filed.
because we
the
are
direction
covered
to
by
the
that
respondent
judgment, because
to include your names in the revised select list.
no, not including license.
That is your prayer, to include your names in the revised select list.
That will be direction of, because by virtue of your judgment Lordship.
Are you going to take an individual case and direct the respondents to include a particular person's name? in the-
Any appropriate direction Lordship, any appropriate direction might be
The
taken.
direction is, please go before the Patna High Court. We'll grant you liberty to file a writ petition. That's all.
My position, no, there's one answer. My position is there are four set of petitions Lordship.
This prayer itself
Three-
cannot help.
three
you. If
prisoners
we have
were
not
lost
to
in the-
open that door,
Three set of petitions
Not
Lordship
even
for
floodgate.
the Patna High Court in the common judgment that passed by the Honorable High Court, and that was against which the SLP was allowed by this Honorable Court Lordship. We did not come to the Supreme Court Lordship, but we were party in the common judgment Lordship. So my humble prayer that Lordship, we are covered by your Lordship judgment, even those who are not
you
eligible.
demonstrated before the High Court, as my brother said,
We'll
go
grant
back
you
to the
liberty.
High Court then. We are
Individual
not
cases
going to
will not be
undertake a
before the
fresh inquiry.
But that will also consume more time, your Lordship.
That is no ground.
Because we are age is passing,
That's no ground.
we are getting over age, your Lordship. My humble prayer Lordship, we should decide your Lordship here.
We will not decide it. We will-
But don't say only 5 years from the High Court, then LPS,
Thank you,
then Supreme Court Lordship.
Yes, Mr.
I'm in 34.2. Now, there are two
That's
aspects.
also content.
Correct. So I'll just point out what is there. Your lordships have rightly pointed out on the principle of Ganpat Duggar Malot's J.S. Pariyar, where your lordships have said that once an order has been complied, then if there is any grievance with respect to the working of the list, etc., then you have to go back to the High Court and go to the appropriate authority. That is the law. I'm one with your lordships on that. Problem today is this, that when your lordships pass a direction, a mandamus, and in that mandamus your lordships give certain guidelines, the manner in which that direction has to be complied with, then my lords, they will be in the teeth of the order of the court if they do not follow it in that very manner. Now, what your lordships have given in this direction, fellows, the principal judgment of this honorable court is this, that the High Court's order of judgment of 19/4/22 has to be complied with. That is the singular
As
thing,
far as possible.
as far as possible, correct. Fellows, 19/4/22.
I was aware, I was anticipating all this. That is why I have put in as far as possible.
As far as possible.
I was anticipating all this.
Well, Lords, I faced your lordships in this matter 3 times while mentioning so. So, well, Lords, now what comes up is this, that if even taking as far as possible, I am going to the factum of the direction which has been passed by this one. Your lordship said, well, Lords, that 19/4/22 has to be, 19/4/22 is only with respect to one thing, which is 40% of the seats, which are for those candidates on the issue of location of the college. One issue was this, that 40% seats reserved for all colleges which were located within the state of Bihar and therefore affiliated to the Technical University of Bihar. Now, my lords, what they have done is this, that after your lordships directed them to rework the list in accordance with the 19/4/22 order, which was only restricted to 40%, the entire list has been reworked. Now, that is the first contempt.
Now, what they have done.
Well, lords, this is what they have done.
Now, what they have done.
So, I'll
Advice means what they have done.
well, lords, 40% of the seats alone had to be reworked. Those 40%.
No.
Lords, the judgment said.
No,
I'll
I'm
just-
sorry, you are absolutely wrong. You are absolutely wrong.
May I have lords then?
You are
Your lordship,
absolutely
my
wrong.
petition. Lords, I'll just read that part. Your lordship.
No, you are absolutely wrong.
Correct.
We have directed them to include to consider each and every person who was not considered on account of 2017 amendment.
That's right. In terms of
And
the order of 19/4/20.
No.
Well,
No,
if you want to see.
it's there. We have, that is why we have said as far as possible.
Well, as far as possible is right. Well, I'm only.
So we are not going to look into all these individual grievances. You please, we grant you liberty to file.
May I just point out the operative part of the judgment of this honorable court at 135, which is 29. If your lordships are correct.
Paragraph.
29, paragraph 29.
Yes.
4th October 24. Now, the first column says, the fresh list be prepared in view of the order dated 19/4/22 passed by the High Court in Surat. Now, what does 19/4/22 say? If you lordships have 19/4/22 for a moment for us. The last paragraph of 19/4/22 is the operative portion. Well, if you lordships have 30.34,
Five in the first one also.
well, it's in 34.
Yes, yes, Manoj.
19/4. There.
There.
Page.
Page 328.
Orders have been issued.
Yes, Your Lordship, 6,500 people have been appointed. I am hearing.
They've already been appointed.
Yes, Your Lordship.
In your
So
lordship.
that
this is
lordship
the
just
matter which
was
has
Still there is vacancy.
Vacancies 4,000. I'm not even going there. I'll just point it out.
Vacancies are there, Lordship. Somebody note why.
But if your lordships may have.
Your Lordship, review of the judgment already stands dismissed.
It has been discussed. I know
And
that.
there are MAs which have also previously.
Wait their turn. So only pointing out what illegality they have now.
These proceedings, some of them file miscellaneous applications for modification and some have contempt. These are mutually exclusive, Your Lordship. They can't proceed hand in hand. You cannot seek a modification of the judgment and simultaneously insist that the judgment is being
Either on the.
They need to first elect. That's number one. So number two, insofar as their grievances that these people have not been included in the select list, the observation correctly included from Your Lordship that they have their remedies available before the Honorable Patna High Court. That's point number two. And point number three, Your Lordship, in this particular case, if Your Lordships, after dismissal of one round of MAs and confirmation in a review petition, would now to entertain this, then the difficulty would be that everyone who stands appointed, their appointment will be under a cloud of doubt. So in these proceedings, my respectful request would be that as Your Lordships are balancing the equities, telling them that they're not impinging on their rights, but at the same time, the appropriate forum should be the Honorable Patna High Court.
That is why I told you.
Read out 19/4/22 if your lordships have. The last paragraph, please have just.
We are looking at.
Because it says, accordingly, appointments made to extent in terms of Rule 4A of the amending Rules 2017 are set aside, and the Bihar State Technical Selection Commission is directed to prepare a fresh select merit list granting 40% institutional reservation to all diploma holders who have obtained their diploma certificate from any polytechnic institute recognized by the AICTU and affiliated by the SBTI Bihar Patna.
So this list would obviously have to change in the light of the second direction.
This- What had happened was this, that this rule says that 40%.
Because this says only AICTE recognized people will be included.
I'll just explain.
Whereas the final direction is that people who are not recognized by the
Only
AICTE
rework
also are to
40%.
be considered.
Now, Manoj, what your lordships have directed is that only rework 40% of this. Now, this 40%,
We have not said so.
40% institutional reservation, your lordships, is directed to prepare a fresh select list granting 40% institutional reservation to all diploma holders. Now, Manoj, the issue before this honorable.
Alam, it's better that you don't ask us to say anything.
No, Manoj,
We're going back
I'll
to the
just,
High Court to have.
just hear me for 2 more minutes and that is it. Manoj, the dispute before this honorable court was this, that in this 40% which was reserved for Bihar, whether members of, whether students who had taken education from private institutions located in the state of Bihar could also compete. They had challenged because the reservation rule set, which was ultimately disagreed with by the High Court, said that only government polytechnic institutions are the ones from which selection to the 40% will be made. But now High Court, with respect, sets it aside, says that no, this 40% institutional reservation has to be given to every college which is located in the state of Bihar affiliated to this university. Therefore, the reworking which has to take place in terms of the final direction in this paragraph has to be only of those 40% seats. The rest,
No.
well, that is the only that is the only sequitur of this direction is my respectful submission. Well, there is no other way in which they can rework the list. Madam, I'm in the middle of my submission. Well, if there is any other manner in which we start reworking this order, will not be able to bear fruit for us. This will not,
Institutional reservation is relatable to some rule 4A.
correct. So, Malad, that, I'll just show that to your lordships. Please, if your lordships have my petition, please have page 139. What if your lordships have?
In any event, Mr. Anand, you're not entertaining these contempt cases now. So why do you want
Let's-
to case to initiate? Go before the High Court if you think the High Court.
I guess.
So have a-
Individual grievance.
Very well, Malad, if your lordships would want to give us liberty, Malad, to approach these.
These other applications which are filed,
34.6.
One- we'll come to. First one is 34.1. MA to clarify that other legal issues remain open for adjudication.
Indeed, my lord. In this, I was
You
appealing.
wish to withdraw it or you want it
My lord,
dismissed?
withdraw with liberty
With liberty to do what?
to oppose the High Court.
No, we won't give you any liberty.
I very well, I vow.
Dismissed as withdrawn. MA, this is 34.1. Dismissed as learned counsel appearing for the applicant. Seeks permission to withdraw the application. The permission granted, the application is accordingly dismissed as withdrawn. Then 34.6. MA to recall the 25/11/24 order, whereby you wanted to file a clarification petition as well as a review petition. So that was dismissed on that ground, but you anyway, now the review,
Yes, sir.
review has been,
One second.
you can't turn back the clock.
I am not saying, please, the folded hands, my AOR could not contact that, I had not filed it. So that,
You did not file a
no,
review.
I had not filed it, that's the problem, please have that order. So therefore, I am only saying today that my clarification application lodged.
There is a question of clarifying now.
Disposed of, no, therefore what was falling from your lordship, not my, my high court petition is pending, I just pursue that, this is what I wanted.
You already filed a
Yes, it's 2893 of 20.
Right.
Lordship just permit me to pursue that.
34.7, MOE will have to go. We can't give individual directions to the commission.
They will not
to
get
include
liberty.
particular person's names.
Because we are covered by the lordship judgment.
If you're covered, you go.
There is no liberty to be lordship given to. It should pass on all high courts.
Then 34, 34.1, sorry, 34, 34.2, 34.3, 34.4, 34.5. Common order.
Yes.
These contempt cases have been instituted alleging willful violation of the order dated 4/10/2024 passed by this court in civil criminal dispensary. Attention of the petitioner that the select list dated 2012/2024 brought out by the Bihar, what is that, Technical Service Commission?
Yes.
Is it? Bihar Technical Service Commission is not in conformity with the directions issued by the court in the aforesaid order. Yeah. The opinion in the event of the select list dated 2012/2024 give rise to any irreducible grievance. The same requires to be canvassed before the High Court and not by way of contempt proceedings before this court. We had to the petitions to do so, if so advised, contempt cases of law. Then 34.1 withdrawn. No. 4.6. Joint counsel proceeding for the applicant states that the order dated 25. The applicant had also filed a review petition in relation to the order dated 4/10/2024 passed by this court in civil appeal notice also, and therefore he would not be entitled to maintain a clarification petition. The counsel, however, states that the applicant never filed a review petition and therefore his clarification petition not rejected on that ground. In any event, the counsel indicates that the applicant has approached the High Court, the High Court of Bihar, Patna, and the dismissal of his clarification petition with the order dated 25/11/2024 would have an adverse impact on the adjudication of the pending writ petition. Stop. Accepting the statement of the Learned Counsel that his application for clarification was not liable to be dismissed on the ground that he had filed a review petition, comma, the order date 25/11/2024 stands recalled insofar as he is concerned, leaving it open to him to pursue his pending writ petition before the High Court on its own merits and in accordance with law. The application is disposed of everything. Then 34.7, the prayer in this miscellaneous application is utterly misconceived, and as it is not for this court to direct the respondents to include any particular name, any particular person's name in the revised select list. The applications are going to be dismissed, leaving it open to the applicant to work out his remedies before the appropriate forum in accordance with law.
And therefore, Lord Lordship, this is also a contempt petition. We are not, should be detached with that.
Sorry, 34.7 is the MA.
His MA is not contempt petition at all. Let me clarify. Yeah.
That's why we dismissed your application, leaving it open to you to work out your remedies before the appropriate.
Wonderful, very good. Lord.
So should very much request the appointments of 6,000 people already.
We've not said anything.
So that
On account of this amendment, large number of candidates have applied for appointment. So how many such candidates have been appointed now?
Your lordships, that's
What number?
AICTE non-recognized
the total
diploma
number of
holders.
appointments is around 7,500, your
Ah.
lordships, which have been made. That came into the context because the state,
No.
sorry,
I want the number of those people who became
Who are-
eligible because of this.
The second paragraph.
your lordships, 6,500 people were already petitioners who were contractual appointments, who then
How
secured
many people have diplomas which are not recognized by the AICTE?
that
That
exact number.
See, when these people will come in, you are bound to go out.
In terms of, they'll have a combined merit list.
That's the problem. That's the
They'll have a combined merit list, therefore people will come in above you.
And the appointment was offered, but not joining also. Some of them not joined. So
Maybe
that's
because
vacancies.
some of them must be working in.
What in your lordship's order is keeping the ones selected as much as possible, adjusting them. So
That's the,
so that was.
So the appointments already made may not be dislodged, your lordship.
you see, for 6 years, no appointments, 10,000.
They've already shown a lot of indulgence in this principal order.
And it was in fact on the basis of concession made by Mr. Patwalia. He was fair enough. He said you can pass this kind of order.
Yeah.
So it was a consensus was right.
I think we've stretched it as far as we.
You were there. You were very much there.
Very good.
Those appointed may not be dislodged.
We have not said anything.
Great.
Grateful.
Great.
Till the 35.